It's 4 o'clock, so I'm going to call this meeting to order. Notice is hereby given pursuant to the Open Meetings Act, Texas Government Code, Chapter 551, that the city of Smithville will conduct a special call meeting on March 23rd, 2026 at 4 p.m. in the council chambers of City Hall, 317 Main Street, Smithville, Texas. The meeting's called to order. We are going to move the citizen comments to the front for this meeting only. So Jennifer, do we have anyone signed up?
I do not have anyone signed up to speak.
Okay. So at this point, I want to make sure that for this meeting, we're going to make sure everyone is present. We have Tyrone Washington, Brandon Dunham, myself, Jim Jenkins, Mitchell Jamison, and Kathy Meek. Mayor Sharon Forrester is counted as present for quorum, even though she is abstaining from this matter. We have a quorum. We are going to move to executive session. Because there are no citizen comments, I'm going to call item 2 and we'll move into executive session. The city council will hold an executive session pursuant to the Open Meetings Act, Government Code 551, in accordance with the authority obtained in section 551.074 to discuss personnel ethics complaint on the mayor. The time is 4:03.
Helps if you turn it on. Caroline McClyman for Mayor Forrester. So we want to make a formal objection that this happen in closed doors in executive session. She would like this to occur in the public so that the community is aware of what the allegation is and what her response is. In addition, I would object to Chief Repka appearing in uniform since he filed his complaint as a citizen. I think that it's a violation of the ethics code if he's appearing in his uniform because that invokes some propriety issues itself. So I would ask that he have to change before he proceeds.
Request to be in contact, not to be that.
Mhm.
Say, and you'll just briefly recess in order for us to transition from that room to this room.
Okay.
5 minutes.
Okay.
With regards to him being here, those uniform, that is something that certainly does create an impression that he's presenting this as a criminal.
I got you. So for us, for legal, this would be better for him to change shirts, and we can give him the time to go do that. Okay. All right. For as far as your request for open meetings, that's going to be granted. There's no doubt about that. We're going to recess for a few minutes while we get things that we have over in the conference room to bring out. And at that time, Chief, if you would please change your shirt and not wear the hat, and then we'll proceed from that point. So we are in recess at 4:04 p.m.
I'm gonna go get over here and bring my hair to stuff. I didn't get ours. This is what I read. I got one. You got one? Okay. You know if this is the ones that want those acceptance. It will have to sign your note. These are all of them. I put my name. Once you get through, what they said before, start on one.
Yes, I have all of it. Mm. So since we're gonna be out in public, I need to say that this is an All right, we're going to call this hearing back into order. So I want to impress on everybody that this is not a public hearing. It is an internal administrative investigation. The public is not invited to participate. Any person who disrupts this hearing will be removed from the proceedings, and I may briefly recess the meeting to refocus the proceedings. So right now, we're going to consider allegations of misconduct against the mayor. These allegations have been provided to the mayor in writing, and she has responded in writing. We will consider both the written allegations, her written response, and their testimony tonight. We'll first hear from the chief, who will present his complaint against the mayor. Second, the council will hear from the mayor on any witnesses she may bring. Third, the council may choose to call their own witnesses. Finally, council will discuss the allegations and decide what action to take in response, if any. Each of the written allegations will be given under oath, witnessed, and notarized, have been given under oath, witnessed, and notarized. Each person making a presentation tonight will also be put under oath before making a statement. So, Chief, Counselor.
Mr. Jenkins, I apologize for interrupting, but I do want to make an objection to David Repka being referred to as Chief Repka at all during this proceeding. He filed this complaint in his individual capacity.
I will accept that.
Thank you.
Mr. Repka, if you will stand up, our council will swear you in.
Mr. Repka, if you'll raise your right hand and repeat under penalty of perjury, do you solemnly swear or affirm that?
I'm sorry, Thomas, can we move him to the microphone for his response? Got to be recorded.
Thank you, Councilman Jameson. That'll allow me to start over and fix my flub from earlier anyway. If you please raise your right hand. Under penalty of perjury, do you solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, thank you, Chief. Thank you, Mr. Repka. Sorry, I'm written from a written deal, okay? Under the Code of Ethics, you bear the burden of establishing facts at this hearing that support your complaint. Your presentation should be limited to the question of whether the mayor violated her responsibility under state law to provide public information in response to your public information request. You may present your complaint now.
So on 9/18/25, I submitted an open records request, requesting all emails, text, and other recording from Mayor Sharon Forrester to any person regarding me or anything to do with the police department. The city responded accordingly, I guess, after getting with her to get the stuff. At that time, I knew that it wasn't complete. So then I submitted another open records request to all the council. And I received an email back with information that she didn't have in hers that was about me. And so she was required to give me that. And then also there was a text message that a citizen had showed me from her that had to do with the police department, and she didn't give me that either. So that's the basis of my complaint.
Do you have anything else that you would like to add?
No. I mean, this is not at this time, no.
Okay, then, thank you. Please return to your seat. We will call you back up if we have any questions. Mayor, would you like to respond? You are not required to make a statement, but if you want to, now is your time. Mr. Gush, will you swear the mayor in?
Yes, sir. Mayor, would you raise your right hand? Under penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you, Mayor. You may present your response, but it should be limited to the specific allegations in this hearing that you violated your responsibility under state law to provide public information in response to your public information request. If you have any eyewitnesses to provide testimony, I will call them in after your statement.
Thank you. Members of the council, I want to address the ethics complaint that has been filed against me regarding the Public Information Act request submitted by David Repka. I take my responsibilities as mayor and my obligations under the Texas Public Information Act and the city's ethics ordinance. What's wrong? Oh, ordinance very seriously, and I would like to explain the circumstances surrounding this matter. When the Public Information Act requested was received, I was notified and provided a letter from the city attorney outlining that I needed to search my records and provide any responsive communication in my possession. No specific search terms, keywords, phrases were provided to me, and I was left to determine how to conduct a search on my own. I relied on the instructions provided by the city attorney and attempted to comply in good faith. I conducted the search of my phone and emails using names and subject matters that I believe were responsive to the request. Based on that search, I provided the information that I located. There was never any intent to hide, conceal, or withhold any information. With respect to the text message involving Marge Jones' funeral home, I had already told David Repka directly that I would be reaching out to Gail Wilhelm at Marge Jones regarding funeral escort records. But I had already communicated with him that I was making that inquiry. There would be no reason for me to try to hide it. It just didn't come up when I searched. Additionally, when I conducted the search of my communication, the text involving Councilmember Meeks from September 11, 2025 did not appear in the search either. This was not intentional. It simply did not appear when the search was performed. It is also important to note that the email I sent to Mitchell Jameson discussing David Repka's salary that exceeded the sheriff was produced in response to the request. If my intent had been to hide communications related to David Repka or the police department, that email would not have been produced. The email was clearly related to the chief and was disclosed, which demonstrates that I was not attempting to conceal anything. Another important issue is that the city does not have standard protocol, software, or systems for elected officials to search text messages and emails for public information acts. In fact, back in September of 2022, there was a discussion about purchasing software that would allow electronic word searches of communications, but Chief Repka declined it. What's wrong?
Interrupt you briefly.
Sure.
Ask you to keep your remarks to things that occurred after December.
Oh, sorry, you are right. I apologize. Okay, then I'll take that. I strike that last part. I relied on instruction provided by the city attorney, conducted my manual search of my communications, and provided the information that I located. It's located. I have marked as Exhibit R001 the correspondence from the city attorney instructing me on how to prepare my response. Human error can occur when manual searches are conducted, especially without standardized procedures, search terms, or software tools. I believe this situation highlights that the city should have a protocol in place for public information acts, searching involving elected officials, including written instructions, standardized search terms, and software capable of retrieving responsive information. This would help prevent situations like this in the future. I want to be very clear. I did not intentionally withhold any information. I did not attempt to conceal any communication. I did not misuse my office in any way. I acted in good faith, followed the instructions provided to me, conducted the search, provided the information I located. The burden of proof to establish that a violation of ethics code has occurred is on David Repka. Under section 1.02.054E, David Repka must establish that I intentionally or knowingly deleted, altered, hid public information without the city having a copy. Under section 1.02.054D, he must establish that I violated a law which has not been established in a court of law or administrative agency. Therefore, he failed to meet that burden. Under section 1.02.054A, David Repka must prove that I intentionally communicated in a way to a reasonable person would feel I meant to improperly intimidate, harass, embarrass, ridicule, or impose an undue influence over another city official, employee, or member of the public in an attempt to influence a person's conduct. In the complaint from David Repka, he does not ever cite what basic forms of allegation that I violated provision A. Instead, the complaint focuses on D and E and two communications. It is important to note that I was not informed that an ethics complaint had been filed until the evening of February 2nd, 2026. This was after a communication from Tom Etheridge and Brittany Oliveira had been emailed to the council about a pending complaint against me. When I received the handwritten complaint, it was difficult to read, and it was unclear if it was asked from the police department references, but I did search the department terms. The council must determine that two communications were responsive and that I intentionally withheld them. As such, the essential question before you today is whether I, as mayor, knowingly withheld public information in violation of the ethics ordinance when responding to the Texas Public Information Act request. David Repka has failed to meet the burden of proof. The ethic ordinance exists to prevent corruption and abuse of office, not to punish elected officials for human error during a manual records search. There is no evidence or intent, no personal benefit, no dishonesty, and no misuse of office. Therefore, the elements of this ethics violation have not been met, and this complaint should be dismissed. Thank you.
Mayor, as you conclude your remarks, in the middle, you mentioned a document R001, an exhibit. I believe you intend to enter that into evidence.
Yes, sir.
tonight? Absolutely. In order to do so, would you do me a favor? I believe your 10 copies are on that table over there. Would you just make sure that Mr. Repka has a copy? And then I can distribute the rest of them here at the dais.
Thank you.
Okay, you got it. Mr. Repka, as a procedural matter, I'm going to ask if you have any objection to this letter being admitted into evidence. Thank you.
We will read into
Could we,
record.
excuse me, should we have him make that statement into the microphone?
For the record, since you didn't speak into the microphone, you have no objection to the letter being admitted.
No
correct?
objection to the letter being.
He has no
submitted.
objection. The record doesn't need to be read aloud. There are copies for everyone to review on their own. All that you need to do is just to admit it into evidence, and then it can be considered as part of our decision-making process.
So we will accept into evidence Exhibit R-001 for consideration in this process. Mr. Repka, at this time, would you like to respond to any of the statements made by the mayor? And remember that you are still under oath.
Just wanted to point out that each one of those pieces of information that I did not get, both had police in them. So I would like you to take that in consideration. And then yeah, that would be it. They both had the word police in them, so that would be all that I have to add.
Thank you, Mr. Repka. Mayor, are there any witnesses that you would like to call at this time to confirm statements?
No, sir.
So we are now down to
The top of page 5.
page 5. Okay. So there are no witnesses, so. Okay, at this point, would the city council like to call any witnesses for this issue?
No witnesses, but certainly, of course, we have the opportunity to ask questions after we determine that we don't have witnesses at this time, but we could call witnesses in the future if information requires us to substantiate.
Correct.
So no council? No one? Okay, thank you. So at this point, this is the time for the council to deliberate among themselves if necessary. If the hearing has been an executive, the mayor or chief may be dismissed. If not, if no action may be taken in executive session after the deliberation is complete. The council should return to open session and announce the time.
Since we're already
Is-
open, we don't need to worry about that.
Yeah.
Right.
I'm sorry, Mayor Pro Tem. Are we asking questions out here?
So, yes, procedurally, the mayor had the right to require this hearing to be held in public, and she has exercised that right. So all questions and deliberation will happen here in public.
Okay, so we're at the point where we're asking questions.
Yes, sir.
I thought we were moving to deliberate. I'm sorry.
But before we get into deliberation here at the dais, why don't we conclude any questioning? So if any council member has any questions for either the complainant or the respondent, now would be the time to do it.
Okay. Do you have any questions?
I do have a question on procedure, if I may. Mr. Gush, you made a comment during the mayor's presentation to not add any comments before December, I believe it was.
September 16th of 2024, yes.
Okay, 2024. Okay, that was my question.
Anyone else?
Yes, please. Before I ask any questions, I just want to say, none of us want to be here. But this is our duty. So the culture we cultivate is the culture we accept. And we need to move forward from this, getting better at everything that we do. I think that we're here to decide one thing, and that's regardless of, and please clarify, Mr. Gooch, regardless of intent or motive or agenda, did the documents exist and were the documents responsive? Is that correct?
That's correct.
So regardless of intent or motive or agenda, I'm asking the mayor, did those two documents exist?
They're both text messages. There was no email from Kathy. Both of them are text messages on my phone that I had to search for. So the one to the funeral home, yes. And then the one that Kathy says is an email was not an email. It was a text, and I didn't find it.
So this,
The both things that are said are correct.
okay, so both of those documents existed regardless of the form, if they were in text or email. You acknowledge that they existed.
Yes, sir.
And Mr. Ghosh, maybe you can clarify this, but Councilmember James's question implied that there was not a necessity for them to determine intent, but it's my understanding. So I just don't want the question to be misleading that they absolutely have to determine if Mayor Forrester had an intent. The statute itself, the ordinance itself requires intent be established in order to have a finding. And so I want the council to be very clear on that today they have to find some piece of evidence that establishes that Mayor Forrester had an intent to withhold the information in the process of responding to that request.
Let's hold and make sure we're within procedure here. So I'm keep your, just hold, please.
Mr. Mayor Pro Tem, the city code does not require intent. However, her question is not about the city code. I believe it's about the Open Meetings Act. And if you would allow me just a quick 5-minute recess, I would like to review the specific language in the statute in order to confirm my understanding of the statute. All right?
So we will go into a break for 5 minutes. If anyone needs bathroom or whatever, we can make it a little longer. Anyone on the dais? Thank you. So we are out of open meeting at 4:55. Okay, we are back in open session at 5:01 PM.
Mr. Mayor Pro Tem, as I review the Public Information Act, this is section 552.233 of the Government Code. Subsection C does not explicitly state a level of intent necessary. It says a temporary custodian's failure to surrender or return public information as required is grounds for disciplinary action. However, I think there's a more complicated answer that is more correct, which is to say that the penal code does require a minimum threshold of intent for any offense where there are potential criminal penalties. And in the penal code, the minimum threshold is criminal negligence. And so I do think that in this proceeding, which is not a criminal proceeding, but does carry with it the possibility of administrative penalties, including fines, including sanctions, I think that we should apply the minimum criminal threshold of criminal negligence as an intent standard. So I apologize for the simplified answer that I gave earlier. I think a better answer would be to apply a minimum intent standard of criminal negligence.
Please explain what the minimum is for criminal negligence.
I'm afraid you were going to ask that. In order for a person's conduct to be considered criminal negligence, the person should at least be aware that there is a substantial and unjustifiable risk that the criminal action will occur. So she needs to be aware that the way that she was searching could potentially lead to her not turning over documents that were required to be turned over. That's my interpretation of that.
Mr. Ghosh, when you say criminal, are you saying unlawful?
The reason I'm using the word criminal in this context is because that's art. This concept comes to us from the penal code and is typically only applied in criminal cases. The reason that I'm recommending that we apply it here, even though this isn't a criminal case, is because it does bear a lot of the elements of a criminal offense in the sense that we are potentially able to sanction her as a penalty rather than simply seeking restitution or some sort of civil fine. Not a clear yes or no answer on this one. You're welcome.
Okay, thank you for the clarification, and that leads me to a question I was going to ask the mayor anyway. Mayor, what search terms were you using? Did you use the word police? Do you have do you recall or have an account of what search terms you looked for?
I know that I used Repka. And I would say I used police department.
So the word police is in police department,
Yes, but it did not show on my,
but it showed the other documents that had police or police department in it. So it's just these two documents that didn't come up in the search.
yes, sir.
Thank you.
You're welcome.
Mayor Pro Tem, I got one more question, but I want to clear this as being relevant or without objection from Mayor's Council. I'd like to ask the mayor what she understands her duties and authority as mayor to be.
So long as you keep that question to the scope of, I think it's an appropriate question. Asking the broader question, what are the duties of the mayor? I think it's the scope of this hearing.
Okay, so Mayor's specific to this complaint, what do you understand your duties and authority as mayor to be?
I'm going to fall back on the fiduciary. I witnessed the city vehicles doing numerous escorts, and I simply had a question. how are our city vehicles if it was a fiduciary statement? I mean, I felt like that was my responsibility to this text message that I sent to Gail.
Okay, and that's what I didn't understand when, if you go back to the initial part of your response,
Okay,
when you
could you
said
give me-
fiduciary, when you were explaining, I believe your understanding of how you were supposed to respond, and please let me know if that's what you're saying. You're saying that you had a fiduciary duty to do what?
To ask how our city vehicles and someone on city duty was responding to a funeral. I just simply asked, is the city vehicles compensated? Are the people that are escorting the funeral, are they compensated? I mean, I asked him and then I saw Gail. And so I sent Gail, could you give me a spreadsheet of the police officers' name who were paid for escort? Would it be too much to go back 6 months? And that was what I sent Gail after I spoke to her and I spoke to him.
So the process that you were following, as you believed was your fiduciary duty, was for you to take on the personal responsibility to investigate without approaching the city manager or the city
I
council?
told him in the city manager's office.
You told Mr. Repka?
When you were in, when I asked,
I believe your question goes to the underlying conduct that preceded the public information request and not whether or not she responded correctly to the Public Information Act request. And so I think it's beyond the scope of this hearing.
Thank you.
thank you.
Mayor Forrester, can you describe the process individually for email and also for text messaging, how you went through and conducted the searches?
I looked at the Exhibit A that he has. I looked at the Exhibit A that he has. I interpreted it as emails, text. As you can read along with me, it was hard to decipher recordings from Mayor Sharon Forrester to any person regarding David Repka, police chief, or anything referred to the Smithfield Police Department. So I used Repka and police department's what I used. And
I guess my question is more about the process, not necessarily what you searched, but how you conducted your search for, and I know there's multiple forms, but because we're only talking about emails and text messages right
Right.
now, those are really the only two. I'm just trying to understand the methods and the ways that you search, not necessarily the exact content of the search terms, because we've already asked that.
Well, I wanted to be clear, I've only had 3 open records requests. 2 of them have been from Chief Repka and 1 has been from the newspaper. And so there's no protocol. I simply just put the words that were in the first time that he opened records and I think everything came up. We didn't have any problem with that. And then he once again sent another one and I used the way he worded this. I used Repka and then I used Smithfield Police Department.
Are we bringing into?
Oh, I went on the search bar in my computer. Oh, I see what you're, I went on the search bar in my computer. I think I asked for help, Jennifer, I think. I can't remember. It was so long ago. I put on my search bar on the computer, I put in Repka and I put in police department and then I printed everything out that came up. And then I went on my phone and I did the search bar and I printed out, or I didn't. Yeah. On the one that from Kathy, when I went back through, because it was an email, I was looking on my email for it, but I realized it was a text. And when we were searching yesterday, and when it came up, it was so large that I just read the first part. I didn't see I mean, at that time, I didn't. I was just looking for police department in Repka.
Yeah. So as far as the emails, you went through on your computer You performed a search through the search bar in the email program. You may have asked for help on that, is my understanding of what you just said. And then the text messages on your phone and the search bar, you search for similar search terms. Did you find anything at that time, or was it just yesterday that you discovered those?
I did yesterday when I went back looking for Kathy Meeks because I couldn't find an email anywhere. And she states that she sent an email, but the evidence comes from Rockin' M Ranch. It's not the, I was looking for emails that she had sent. And then I guess she copy pasted and then she emailed it from her personal email to her city email. That correct? Okay, so then I didn't see it.
And to just provide clarification, I took her phone yesterday. The font is large to accommodate a need to see the text larger, which happens to us as we get older. However, when you do that, when I ran a search, I didn't see it, but I'm more tech savvy. So you have to press it, you have to open it up, and then you have to scroll. So when you run the individual search, because I did do that for the word police separately, that's how I was able to find Councilmember Meeks' text yesterday and learned that was news to Mayor Forrester that it was a text. But it took a process, and when you ran the search, it didn't come up. I had to press into the text, then open it, scroll down. And so I could see if somebody's not trained properly, that they might not know. And so I just wanted to clarify that since I had to assist her in that process yesterday.
So just to clarify further, it's not something that you found on your own yesterday.
I did not. She found it. Yes, sir.
Do we have any more questions? Okay, I think the chief was wanting to respond. Chief, you were wanting to respond before we went on break. Are you still wanting to respond? I'm sorry.
I would just like a little more clarification on that this is not a criminal proceeding. And so I'm confused at why we're having criminal standards and what would be more related to a civil proceeding. And as you stated, negligence is in the Freedom of Information Act. It's not just intentional, as the lawyer pointed out. So I think the burden of criminal negligence is a lot higher than just negligence. And so I just wanted some more clarification on why we're using a criminal standard in a non-criminal court. And it should just be the preponderance of evidence, 51% or more. This would be related more to a civil proceeding than it would criminal. Is that not correct?
Mr. Mayor Pro Tem, in the rules that we had established for this proceeding, the witnesses were not intended to ask questions back to the board. However, in this case, because the attorney for the mayor previously raised an objection, which I did explain my answer to, I think it is probably appropriate to further explain if it's something you would allow.
I will allow.
Thank you. As I said in my prior explanation, this is not a simple cut and dry situation because this ethics board has the capacity to impose penalties, not just civil fines or restitution. This is more of a quasi-criminal proceeding than it is a quasi-civil proceeding. And for that reason, I believe it is appropriate to require the higher level of intent that is necessary in a criminal proceeding than it would be in a merely civil proceeding. Thank you.
If I may ask a follow-up to that question. So for the burden of the evidence, are we looking for a criminal level of evidence beyond reasonable doubt, or are we looking for a simple majority?
No, again, this is going to be a complicated answer because this is a complicated board. But the standard, you just asked a question and you referred to two different things in it. You referred to beyond a reasonable doubt, which is a standard of proof required in criminal court, all right? The corresponding alternative to that would be a preponderance of the evidence, okay? And I believe that in this case, a preponderance of the evidence is what should be applied because it's still an administrative hearing. It is not a criminal proceeding, even though it is quasi-criminal. The other term that you used was, I believe, simple majority.
And that was a misstatement. It was more, I just didn't know what the.
Absolutely.
fancy
I just
word
wanted to
was.
confirm with you that yes, a simple majority is going to be the vote that will be required by the board. Thank you.
Further clarification, please. So we're considering whether the preponderance of the evidence rises to the level that the two responses that were not provided, now that they do exist, whether or not they would have been or are responsive to the open records request.
If I may state the standard that I believe the council needs to be considering right now. You need to be considering whether the mayor should have known that the process that she used was negligent and would have resulted in her not providing the records that had been requested. I don't think I said that quite right. You need to decide whether her conduct was criminally negligent, which means that she should have known that this conduct would have led to her not producing the records, but she didn't know that, even though she should have. And that her conduct didn't produce the records because she did not avoid the negligent behavior.
So if she had done more research on what she was required, what process she were required to go through, then she would have known that her process was somewhat limited and not identify these documents. I'm just trying to do this out in public because I don't want to do this in the back room and have people say we're not being transparent.
I understand. And I'm just trying to parse your question before I answer. Because I thought you were asking me to make a determination about whether she would have known that she needed to act in a different way. And I think that's beyond my answer. But the way you phrase the question, I think, is what you need to be considering. Did she act in a reasonable way for the mayor receiving a request, knowing that she had an obligation to produce these records? Was her conduct negligent in not doing what a reasonable person would know she needs to do? If her conduct was negligent, then it meets the minimum intent standard that I've set out.
That was good. Thank you.
Did that finally get there? Okay, good.
You finally got it. I'm a little thick-headed.
This isn't so much a question as a statement, but it's a little, it's confusing because the standard she used and the procedure she used to try to locate, to using the keywords and try to locate the documents, she says she did that to the best of her ability. But no one was overseeing that process, and no one was saying, no, you didn't go through the right process, you didn't dig deep enough or whatever. So I find it difficult to make a judgment here because she has stated she did everything she knew to do, but yet in the world of emails and texts and all the stuff we have going on now, I don't know how to dig deep to find things in my email or text. I mean, I know there's advanced searches, I know how to do that, but beyond that, unless you're a real techie person and know how to do all that, it seems like she did what she thought at the time was the reasonable method of finding these documents. But if you look at the bigger picture in the tech world, there's more she could have done, which I may not have known, you may not have known, someone else may know or may not know. I'm just saying there doesn't seem to be a standard that was followed, and there was no oversight for her to do anything different, if you will. I don't know if I'm making much sense, but to me, that makes sense.
Mr. Gush.
Gavel them down.
Okay, at this point, please, don't, we are nothing like this. We need to keep this quiet. This is a semi-legal matter, so let's leave it like it's supposed to be in a courtroom, okay? Thank you.
One second while I remember my. The evaluation, the complaint has a lot in it. But the only things that we're evaluating today are not the content in the messages. Unless we believe that it has a bearing on intent.
I'm not sure I understand your question, but part of your question has to do with the fact that a significant portion of the complaint was dismissed. Some of it was untimely. Some of it was dismissed because it didn't meet the minimum thresholds in the Code of Ethics. The only part of the complaint that remains is the question of whether or not the mayor failed to meet her duty under the Public Information Act to produce records that were responsive to his request. And so we have been limiting the scope of our discussion solely to the two transmissions, one alleged to be an email, one alleged to be a text message. That Mr. Repka has specifically said are violations of her obligation. Those are the only questions that we're asking at this point. We're not asking any questions about the conduct that may have led up to those messages being transmitted. Did that answer your question?
It did.
Thank you.
So despite the fact that the mayor mentioned that this is the second time that we've been through this, we can't consider that.
That's correct. We are here only considering the portion of the complaint that is still valid in front of us.
And both of these were text messages. They were not emails, is my understanding.
Yes, that is correct.
Can you clarify the next steps of what is happening? Because I thought this was all out, and then Councilman Jameson mentioned we may be going back to the back room, and
As far as I'm concerned, we will not be going to the back room. They have asked for this to be an open meeting. It is going to stay an open meeting. Excuse me?
Would you like for me to look through the next steps?
Yes, if you would, please. That would make it much easier. I was just going to say we're going to close questionings and go to deliberations. But that's where I'm at.
That is where we are in the process. The remainder of the process is once council decides that they have no further questions for the complainant or the respondent, then council will be able to deliberate among themselves. And at that point, the discussion will only be at this table. It will only be discussion among the council members. If you have a legal question or a procedural question for me, I will answer it, but I will not otherwise contribute to the discussion. After that, there will be an opportunity for any council member to make a motion that they want to make. I recommend that the motions that be considered tonight be broken into two parts. First, that there be a motion to consider whether or not the mayor is responsible for misconduct. All right, I'm calling that the motion on responsibility. In the notes that I prepared for you, I prepared some sample language for how a member might choose to make that motion if somebody wanted to. But then secondly, only if that first motion passes, should council consider a second question on whether there is any penalty assigned for that responsibility. And there are numerous possibilities set out in the ethics code. And so I tried to craft sample motion language for you around each of those options that is in the code of ethics. Of course, the last option in the code of ethics is or anything else. And so I crafted a sample motion that is just a fill in the blank as well. All right. Once those motions are complete, then this hearing will be over. There is no obligation to make a motion, just like any other city council meeting. When an item is called, If there is no motion made, it dies for lack of a motion. If there is no second, then it dies for lack of a second. Any other procedural questions for me before we turn over to deliberation?
One more, because we keep referencing the procedure that we're going through right now, but this is not a public document.
After this hearing, this document can be made public. I have this document marked as confidential and privileged attorney-client communication, and it is that, but if council chooses to release it, they can vote to release it.
We would have to make that decision out here or in deliberation
In public.
in public. Would it be germane for me to make that motion right now? Because I would like the public to see the process that we're using, because there's a lot of confusion about what's going on.
I would rather we got into deliberations. Let me close this out for answering questions. We'll go into deliberation because that is where we can make motions. Am I correct? Yes. So we are going to close out the questioning part for council, and that is closing at 5:28. And we're going into deliberation, which we will be doing out here. We are not moving. We will be doing it out here. So that's where we are. So deliberations start. Any comments, any motions or anything moving forward? Where are you standing? Mitch, if you would like to start, you may start.
Just want to ask a question about procedure. We're in a public forum right now, but it is a closed meeting. And so I just want to understand who is allowed to talk right now.
Thank you. We are not in a closed meeting, all right? We could have been in a closed meeting under the Open Meetings Act unless the mayor requested that this discussion take place in open, which she did at the beginning of the meeting. And so all of this is considered open session. However, this is not a public hearing in the sense that you would be inviting the public to participate. And so consequently, that was the admonition that the Mayor Pro Tem read at the beginning of the meeting, to say that this is the time only for council to be discussing and not to be hearing from members of the public.
And also that excludes the mayor, Mr. Repka, and the mayor's attorney.
They have had their opportunity.
Okay.
I would like to hear from the Mayor Pro Tem and Councilman Jenkins, their opinions of what the process, well, your thoughts on what's been going on here right now. The three of us have been talking about it.
As I have listened to everything and we have gone through the questions and gone through all the answers that we have gotten, this comes down to one thing and one thing only. It comes down to intent. If intent has been proven, if you believe it has, then we would proceed on from that. If there is no intent, then we are basically over at this time. That is where we are,
In your opinion?
in my opinion.
Okay, thank you.
This is where we're talking about our opinions though, right? So, I mean, what is everybody thinking? What is everybody thinking? If this is a section about their opinions, I know the procedure.
Well, I came in with a different mindset based on what we were told the thresholds were. And so when I came in, the question for me was, did the documents exist? And if they did, were they responsible to the request? Responsive, excuse me. I think it's obvious they were responsive. She's acknowledged that the documents existed. Then the question became, what's the threshold of negligence in this point? So we're basically being asked to determine whether or not a proper or reasonable process was used to find all documents that would be responsive. It almost puts us in a position of evaluating our own procedures, which is, I've said all along, it's clear that our ethics policy is something that we need to study ourselves. The ethics policy we created, I believe, in May, and the mayor signed it. We have an affidavit saying that we have all studied it, read it, and understood it. But now we're being asked to read someone's mind, which is a very, very difficult thing to do. We're not allowed to expand this discussion beyond these issues. The complaint gave some rationale about why he felt like the behavior was there, but we're not allowed to go into that. We're just sitting here trying to figure out, did this rise to a threshold of intent? So, I mean, we're in a very, very difficult spot.
Anyone else?
I know I tried to explain myself a few minutes ago, but I have to say that I think of myself doing this, and I think of trying to go and locate a text or an email, and I would do the things that I knew to do. And if I was just there by myself and I was being instructed to do this and there was no one overseeing it, no one giving me a real standard of protocol or an explanation of exactly how to go about completing that task, I may not have found them either. I'm not addressing the intent part. I'm simply restating that I think when you're asked to do something that comes down to something this critical and important, there should be a standard of protocol of how to go about finding that's the same for everyone. And the mayor stated, she did what she knew to do, and no one questioned that until now we're questioning it. So I feel like there's a big disconnect here on how this whole process unfolded because there wasn't any oversight or protocol as to how she should have gone about producing or finding those documents if they weren't right there in front of her.
Are we not allowed to ask a follow-up question of the mayor?
That would be a decision of the chair at this point. You can ask for permission to ask a question of the mayor. But since we've already closed that section of the meeting, he would have to open it back up. So it's up to the mayor pro tem to make that decision.
Do you want me to tell you the question I want to ask or just ask for permission? Mayor Pro Tem.
Quite honestly, I think we have done enough questioning. We know exactly where we are and what we need to do. I'm not going, if we're going to continue to deliberate this to death, and I believe we should deliberate it, we have done that. We have asked all the questions of the mayor and everything. You have had plenty of opportunity. It would have a heck of a question for me to open it back up.
Okay, I appreciate that. And there's a different way that I can phrase it because I would like to respond to Councilor Meek and the comment that you just made. I mean, one of the things that I think that we should consider is at what point, since it took assistance from legal counsel for her to find the second document, at what point did she obtain legal counsel? I believe she had legal counsel during the initial 10-day period where she was going through the process of being responsive. So that's something that certainly we should consider.
I will not ask again. If anyone responds again, I will move them out. We will not say one way or another. You can respond after we get out of this.
Mr. Jameson, are you saying that during the response to the complaint or during the response to the FOIA request she had counsel?
The response to the FOIA request. I believe that she had legal counsel at the time.
Okay.
But I can't confirm that. But it's just part of this is, rising to the threshold that we've got to look at. Again, we can't read people's minds, whether or not a reasonable person would have gone through a process that found these two particular documents, which are, in my opinion, clearly responsive. But they weren't found, but the other documents were found. That's my comment.
Okay, I'm going to limit this. This will be the only question I will open this back up for. You may ask one question and there will be no follow-ups or no anything else.
Yes, sir.
We are out of deliberation and back into questioning by council. It is 5:37.
Mayor, did you have legal counsel during the period of time when you were responding to the open records request?
Attorney-client privilege communications.
You should.
It requires what?
Attorney-client privilege communications. If, whether she had a relationship with an attorney and had hired one, would ask for confidential information that you're not entitled to receive.
And I will uphold that. That is, yes, that, and I, on the council of our council, that sounded weird. That is what we will do. So,
I'm done.
all right, we are back out of council questioning and back into deliberations at 5:37.
I'd love to hear your thoughts as well too.
I have already said mine. I believe this all comes down to intent. At this point, there is, intent is a mindset. Intent is, was she purposely holding back? She has stated she did not. I don't know how you would improve, prove that unless there was something written somewhere where she said, okay, I just am not going to send this. That has not been done. There's nowhere has that been recorded or seen anywhere in this. I cannot move forward with a motion for responsibility without some sort of proof of intent.
I think for me, before coming into this meeting, my understanding was there was both an email and a text message. And for me, in a way, that was more damning because it's not a procedural way of searching. It is looking and omitting something with a specific keyword, a very, very relevant keyword for this specific FOIA request. And for me, that seemed to show negligence, that she was missing it in both text and email. Hearing that it was in text only, both of them were in text only. And my own struggles with iOS search, knowing specific keywords that are in messages and still not getting those keywords to pull up on my phone, but I can get them to pull up on my Mac. I can't in good conscience say that this is negligent because there are keywords that are, I know that and it happened today that I had to search 3 different words to get one message to pop up. With that said, I'm not fond of the content of the messages, but and the actions resulting in those messages, but that isn't up for discussion today. And purely, I mean, anecdotally, I mean, you were trying to find your own message and couldn't find it a second time. And I think that those elements for me, that's where I'm at.
So reading the room, Mayor Pro Tem, I sense that we're possibly not going to be going forward on a motion and second on responsibility. For us as a council, that certainly means that there are issues brought to light that we as a council should be considering for all of our behavior going forward.
And that is a discussion for a different place and a different time.
I guess we need to purchase the app so we know everybody can be doing it the same way going forward.
Right now, where we are, if I'm reading, as I say, as you're reading the room, then there will be no motion, so that makes this a dismissal. We do not have to do anything else for that. Am I correct?
Mayor Pro Tem, for the purpose of the clarity of the record,
Mm-hmm.
would you formally ask if anyone would like to make a motion?
Would anyone like to make a motion at this time?
No.
No.
Kathy? Brandon?
No.
It's a no for me. Then I believe that this council meeting is now completed and we are adjourned.